That's the new argument and the new attack that Florida State is levying. If there is no requirement of Florida State as a named member institution in the ESPN agreement, and why would they be named individually, then there is no mandate for them to be a part of the ACC necessarily.
Pleased to be joined by a special guest. You heard him recently, a couple weeks ago here on the channel, Doug Rohan from Rohan Law in Atlanta. Doug, I appreciate you joining me again. We're having you on today to break down Florida State's second amended complaint. So set the scene for us with what's going on here in this second amended complaint from Florida State and why this is particularly significant.
Sure. Well, as we discussed before, Judge Cooper in the Florida case had chastised the Florida State attorneys for not putting enough information in their jurisdictional section. They're trying to claim that the ACC is subject to the jurisdiction in Florida. So he went ahead and dismissed their entire amended complaint as it was previously filed. Florida State then had a chance to kind of tear everything down to the ground and rebuild their entire case. This now came after Clemson filed its suit. So we were curious to see what elements of the Clemson suit the Florida State attorneys would include. And so this week we got to see Florida State's second amended complaint. And there were several changes as we anticipated. First off, the jurisdiction section went from 7 lines to 13 pages. So clearly they got the message that they needed to be more robust in showing how the ACC does business in Florida. And then the second part was they wanted to go ahead and start talking about what the new counts are. And they included this idea that Florida State could unilaterally leave the grant of rights and could leave the conference and the house of cards would fall. So that's one of the biggest arguments that they changed. And then, of course, they also talked more about sovereign immunity. So there was a big distinction drawn between how North Carolina was handling sovereign immunity and how Florida law should handle sovereign immunity. But those are really the 3 biggest changes that took place in this second amended complaint.
Okay, I love that. It's a great way to break it down in a much more digestible portion, I think, for everybody here. So which of those to you is the most important? Like I assume it is the middle one of those 3 that you talked about.
Yeah, they have a new count 1. And as we've talked about in lawsuits, attorneys typically start with their strongest arguments or what they believe to be their strongest arguments. And then they throw in other reasons why they should win on the merits of their case. So here, Florida State very clearly said, look, the ACC has misinterpreted the grant of rights. The grant of rights does not mean what everybody thinks it means. And they broke down what their explanation was. The ACC grant of rights is for the benefit of the ACC to negotiate with ESPN over a media deal. That's consistent with what we know. That's consistent with what we've talked about before. But what's very clear is that the grant of rights solely operates to facilitate the ESPN agreement. So that means that first, if there is no ESPN agreement, there is no grant of rights. The second and newer argument is that the ESPN agreement with the ACC, which does not include Florida State as a party, is simply laying out what the obligations are for ESPN to broadcast member games. So if Clemson and Florida State are no longer members, then there are no rights that are required in the agreement between ESPN and the ACC that are conveyed. That's the new argument and the new attack that Florida State is levying. If there is no requirement of Florida State as a named member institution in the ESPN agreement, and why would they be named individually, then there is no mandate for them to be a part of the ACC necessarily.
So essentially what that boils down to for me looking at it then is saying grant of rights, like that whole price tag that was like $570 million, whatever it was, scratch whatever the grant of rights piece of that is. We should be negotiating here an exit fee and get down to brass tacks on that because the grant of rights shouldn't apply. Is that a correct interpretation?
That's their first and best argument. That's what they're trying to allege. They want that number to be 0. And I've now come around on this thinking, look, just like everybody else, when we first heard about Ironclad and that this is, an insurmountable contract, it's irrevocable, it sounds great. But once the attorneys actually start peeling back the layers, piecing together what the words mean and how they're being structured together, it really doesn't mean what the headlines suggest. So there are conditions on those grant of rights, one of those conditions is that ESPN has to be the broadcast partner. So we already see how there are chinks in the armor. And as you continue to dig, you can find these other threads that run through the agreement that would make it such that Florida State and Clemson can unilaterally exit. Now, even the exit fee is under attack, and they are pursuing a claim that those exit fees were improperly escalated after Maryland left. And so that's something that's going to be addressed as well, is whether or not that's even valid. So Florida State did not go so far as Clemson did. Florida State did not claim damages to their title or to their brand the way Clemson did. So in some respects, Clemson is trying to say, not only do we not owe anything, but you actually owe us money. Whether that's valid or not is a matter for a different day. But as part of the negotiations that everybody hopes this leads into, it does mean Florida State's negotiating between 0 and 700 million, and Clemson is negotiating between getting 100 million and paying 700 million. So it does kind of change the metrics of where those negotiations are going to go.
Well, some of this will depend on timing, obviously, because I'm about to talk to you about a deadline that's coming up in February. So this would have to extend to that. But obviously, ESPN has that decision as to whether or not they want to extend the ACC contract for the back 9 years on that in February. If they decide no, and this is still a pending case, like something's going on here, and maybe that's even an unrealistic scenario, but how would that shift things if that were the ESPN decision in light of what Florida State is arguing here?
Well, the first thing that's very interesting that's come up since our last conversation is the ACC meetings in Amelia Island. And Jim Phillips was questioned about this as to what the relationship with ESPN is. And he was saying, that it's great. We're just working out a few minor details. He didn't elaborate, but those minor details are whether or not this is going to be extended or not extended. There was a follow-up question. So Phillips characterized this as a look in, and I've heard that a few times, that ESPN has the right to look in and perhaps renegotiate. But the way Florida State laid it out in their complaint is that this is a unilateral option. That means that there's a positive aspect, there's a positive action that ESPN would have to do to extend the contract to 2036. Absent an affirmative approval of that extension, then the agreement expires in 2027. So first, there's the question of what is the nature of this look-in or option that occurs in February 2025. And then second, is there a legitimate concern or question of whether or not ESPN is going to extend this through the 2036 season? Because if ESPN is looking at this saying, look, we're already paying below market value and that works with our finances, are they still paying below market value if they lose the two biggest marquee properties of the ACC? And I believe the answer to that is no.
I'm glad you brought up the ACC meetings, because one thing that we got out of that, it was Brett McMurphy who reported this at least first. I saw him most prominently putting this out there, but that ACC sources were telling him, like, look, the ACC is not going to settle. Like, why would the ACC settle? I'm paraphrasing here, but they looked at it like, what leverage does Florida State have to think that they would force the ACC into settling? And when we last spoke, we kind of thought, this is probably, at least I certainly did, headed toward a settlement. So what do you make from that attitude coming out from the ACC through Brett McMurphy at their meetings?
That's a fair perspective. In one regard, the ACC is staring their own demise in the mirror. How can they navigate a successful resolution where they continue to survive and thrive? And that's a very narrow hole in the needle to thread. What the parties say publicly is always taken with a grain of salt because you're posturing. They want Florida State and Clemson to feel like that number is going to be as high as possible for them to exit. Sure, it's possible for a party to say, we're not going to compromise, we're not going to settle. I have a lot of clients who at the start of their case say, I'm not going to settle, I want the surgery. But as this continues to drag out, you're going to see those appetites change. And that's why that February date is so important. The reason why the ACC should be considering settlement, if I was advising them, is because the only way to successfully win is to win across all of the arguments on every aspect in both suits. So you've got at least 4 cases right now that you have to have a clean sweep to declare victory. And what does victory look like? Clemson and Florida State have to stay in your conference until 2036. You don't actually get any money, they just can't leave. So what's the alternative? You basically are forcing two spouses to continue cohabitating when they don't want to live with you. How is that going to continue over the next 9 ACC annual meetings? Alternatively, after deciding whether or not you want to pay 4 legal teams to litigate 4 cases, you have to do the cost benefit analysis. Can you get a number high enough out of Clemson and Florida State that only those 2 teams can afford it? Because if you can do that, then you're filling your coffers with $450, $500 million while also maintaining all the other members of your conference. If you lose, if you say, I'm not going to settle, and you lose, that means that exit fee goes to 0 or a relatively nominal amount. That grant of rights goes away completely. And now there's nothing holding any of your members together in the conference. So while they may be publicly saying we have no appetite for settlement, behind closed scenes, that's almost always a terrible, terrible strategy.
Yeah, I mean, if Florida State and or Clemson is victorious here, that basically means, right, that the door is just wide open for anybody else, North Carolina, Miami, whoever wants to leave like the next day they can, or do they have to then take it through the legal system again? Like, how do you foresee that working if that were the outcome?
Well, whatever happens in either case is going to be applicable to the conference as a whole. So one way that Florida State could get out of this is to say, yes, there was a breach of fiduciary duty and the ACC failed to negotiate its contracts in a way that profited the members. Let's say that's the point they went on. Well, that applies to the entire spectrum of ACC members. There's a breach of contract. Let's say at some point, and this is a tougher one because of the statute of limitations issue that comes with breach of contract issues. Florida State did wait a long time. That's a valid complaint. And why is FSU creating this litigation so long after signing the contracts? Well, the breach of contract statute of limitations is based on when the breach occurs. So what was the breach and when did that happen? As long as that happened in the last 5 years, then that is a valid claim. If it was something 6 years ago or further back, you can't pursue a breach of contract claim in Florida. If alternatively, the declaratory judgment action interprets the language in the way that we laid out at the beginning, there is no statute of limitations to that. There's no defense to that. That's just what the words mean. And if the court agrees with either Clemson or Florida State that the words mean what they're alleging, then the grant of rights doesn't hold any member institution together. So there are some significant risks. And for that reason, it would be foolish for the ACC to decide this is worth a 3-year legal battle.
Yeah.